Perfect. Okay, I'm going to chat about intellectual property this evening. I don't know if I'll need the full 10 minutes. I doubt it. My name is Kyle Torrington. I'm the co-founder of Legal Legends. We deal with all sorts of commercial, labor, intellectual property related issues pertaining to startups and businesses out there. And we have been doing so for the last 6 or so years. So with intellectual property, there are 4 main sort of subsets of intellectual property: trademarks, copyrights, patents, and designs. Now, I'm going to give a broad overview of each. It's going to be very high level. There's a lot to know in respect of each, but hopefully it will give your cohort some sort of general understanding of what each is, or at least the ability to differentiate between the various forms. So trademarks. What is a trademark? It is simply a form of intellectual property consisting of a recognizable sign, design, or expression which identifies and distinguishes products or services of a particular source from those of others. So, very high level, this could include brand names. For us, Legal Legends is our brand name. It serves to distinguish our particular brand from those of others. Product names, if you look at trying to think of a specific product. I don't know. Microsoft Mouse, for example, I suppose it's a brand name, but it could also be considered a product. I mean, that serves to distinguish a specific product from those of others out there. Logos, once again, is a sign which serves to distinguish your specific brand from others. Jingles, too, for example, different sound snippets that could also serve to distinguish your particular brand from that of another brand. In addition to that, shapes. For example, the Coca-Cola bottle, the sort of woman figure, I think they dubbed it back in the day, that is distinguishable from that of other bottles, and it was trademarkable and in fact trademarked back in the day. Now, one thing I do believe that your cohort needs to know, a lot of people are under the misguided understanding that by reserving a company name, enables them to have exclusivity or monopoly over that name. The reality is that it's not the case. If you register your company with the CIPC, even if your company is available for registration as a company name, it does not mean that you have the exclusive rights to it. The unfortunate reality is that you have to go about searching and registering for a trademark in order to ensure that you have some sort of a monopoly over it. So that is very, very important. And I've seen a lot of companies get into trouble with that. And they approach us with, as I say, the misguided understanding that, oh, I've registered my company with the CIPC. It said my name was available, therefore I deserve a monopoly over it. The reality is that is simply not the case, unfortunately. So very, very important there. How to register a trademark. So although we would always advise that you seek the help of an attorney who would have very good knowledge of how to search the various classes, because it's not simply a case of determining, well, let's do a quick search and without knowledge of what the specific classes pertain to. I mean, there are 45 different trademark classes depending on the product or the service that you offer. And there can be coexisting trademarks in different classes which have very similar names. So without your ability or without you having the knowledge of how to discern the different classes, nor what class your particular product or service falls within, it would be very hard for you to determine whether or not you're registering or searching for your mark correctly. However, if you want to go and search or register for your trademark, you can do so at that particular CIPC URL there. It is a very drawn-out process. That is the reality. You file it today, it'll probably be registered in, at best case, 18 months from now. You'll only know whether it's accepted about 9 or so months from now, but there unfortunately is no way to go about it apart from that. Also, I think worth speaking about, a lot of people think that by filing a trademark in South Africa, they have protection the world over. That is unfortunately not the reality. You have to, unless there are certain exceptions, especially if you're part of almost every other country apart from South Africa, where you can file a World Intellectual Property Organization trademark. But if you are from South Africa and domiciled here, you need to unfortunately file your trademark in every single territory that you have every intention of trading in. So very, very important. Don't think by filing in South Africa, you've now got protection worldwide. And also don't think that by filing in South Africa, you'll have the same brand name available overseas. I mean, it's something you might not know at the very nascency of your business, that you are going to expand into these markets, but it is worthwhile knowing, or at least having this in the back of your mind. Copyright. What is a copyright? So it is essentially, once again, a form of intellectual property that gives its owner, which is normally the original creator, the exclusive right to copy or distribute a creative work, usually for a limited period of time, around about 20 years. In some cases, I believe it's 50 years. Copyrights arise automatically on creation. So this is very important. And it will lead me on to, and I'm going to go back to the previous slide. They arise automatically on creation, and they do not need to be registered in South Africa. So unless it's, for example, a film. So what might a copyrighted work comprise? Literary works, for example, blog articles, journals, books, for example, novels, motion pictures, sound recordings. And this is where you might notice a few overlaps between copyrights and trademarks. I mentioned originally jingles could also be the form of a trademark, provided it distinguishes your brand from others. Sound recording could also be, or certainly is, the product of a copyrighted work. Then there are paintings, drawings as well, logo designs. Again, an overlap. A logo is both the subject of a copyright, and because it is a sign which distinguishes your business from that of others, it would also be regarded as a trademark. Then photographs, computer software code, very important. A lot of you are going to be, certain in tech-related businesses, or at least have a product such as a website, which might be the subject of software code and therefore a copyright. Then there are radio and television broadcasts. Now, I've briefly spoken about the overlap between copyrights and trademarks, so I'm going to gloss over that particular slide. Something very important to realize. Generally, when you outsource works, these creative works that we've spoken about, such as the writing of blog articles, the developing of a website, for example, the external supplier that you outsource those works to, unfortunately, owns the works, unless they enter into a written copyright assignment agreement. Very important. It has to be in writing. So if you've outsourced your website development or blog articles or anything to that effect, please, please, please ensure that you have this in place. We've had a lot of examples of software developers, external software developers, that have held websites in hostage just because they've got legal advice to the effect that they own the particular website, until the founders have had to start again and redevelop the site from scratch, or effectively pay a ransom, purchase the website back, or license the website. So very, very important. Patents. What is a patent? I just need to caveat this slide. We don't offer patents through legal legends. It is a very specialized form of intellectual property. But it is a form of intellectual property that gives its owner the legal right to exclude others from making, using, or selling an invention or an inventive step for a limited period of 20 years. So very important here is an invention, a unique hinge design, for example. You can have a unique composition of a recipe that could also be regarded as an invention, but it cannot have been seen worldwide. Important to note is that generally business ideas certainly aren't patentable. For example, the concept of Uber, the concept of Facebook is not patentable in and of itself. We have a lot of people come to us and say, I've got this business idea, a general business idea, can I protect it? Well, generally, you cannot protect the business idea as a whole. Aspects of it, though, you could potentially protect via copyrights or trademarks, etc. Examples of patents: an aircraft, for example, at one stage was an invention. Bicycles, wheelchairs, solar cookers, for example, are all examples of inventions that were patented at one stage. Important to note that after 20 years, the patent will be, although it is disclosed to the public at the start, it will fall away. And if, for example, KFC decided to patent their famous recipe, whenever they started, 100 or so years ago, their recipe would have been disclosed to the public and would have fallen away after 20 years and could have been used by anyone. So it's also important to decide whether or not you want to disclose the components of your patent to the public by virtue of filing a patent. Patents can also be registered with the CIPC. You can conduct an availability search there at the same link that I provided earlier for trademarks. It's effectively 2 steps. First of all, you file a provisional patent, followed by a complete patent 12 months later. Once again, it is geographic based, and you have to look at, if you're looking for a worldwide patent, you would need to look at filing in all regions across the world to get protection the world over. Then we have industrial designs. And an industrial design is effectively, once again, a form of intellectual property that protects the shapes or features of an article that appeal to the eye. This can include the shape, form, pattern, ornamentation, and configuration of a product, such as the design of a ring. Obviously, a ring itself is not an invention, therefore not the subject of the patent. But if it looks unique enough and it is appealing enough, it can be registered as an industrial design. For example, the unique shape of a handbag could potentially be an industrial design. The unique shape of a computer mouse, the unique shape of a desk could all be industrial designs. There are 2 forms: an aesthetic design. It has to be new and original. The beauty is in the shape or configuration or the ornamentation. So it doesn't have a functional purpose, but it just looks a certain way. And it has a lifespan of 50 years. An example is jewelry. Jacobus, I'm nearly done. I understand my time is up, but I've got maybe 2 more slides. Then you've got functional designs. Once again, has to be new and not commonplace. And the shape or configuration of it is necessitated by the function. It lasts 10 years. And for example, this might be, I don't know, a hoodie with built-in earmuffs. The shape or configuration is necessitated by its design. Earmuffs need to be in a certain place, for example. So that's a functional design. And once again, you can register it at the CIPC at that same link that I provided. And that's that.